What if you paid tax honestly? You bought goods from a registered dealer? You have genuine invoices, and yet the tax department tells you, sorry, your input tax credit is denied. Sounds unfair, right? Well, the Supreme Court of India agrees with you. In a landmark judgment, the Apex Court has stood by the side of genuine taxpayers, and it could completely reshape how ITC disputes are seen under GST. This case came up under the Delhi VAT regime in the case of Shanti Kiran India Private Limited, wherein the department filed an SLP against Delhi High Court judgment, which was dismissed by the Supreme Court recently. Here's the big question before the Supreme Court. Can a purchaser be denied ITC if they have paid tax to a registered seller through valid invoices, but the seller fails to deposit that tax with the government? And the court said resounding no. The division bench of Justices Manoj Mishra and N. Koteshwar Singh ruled that a bona fide purchaser cannot be punished for a seller's default when there is no dispute about the seller's registration or the genuineness of the invoices. The court backed its reasoning with solid legal precedents. In Quest Merchandising India Private Limited, the Delhi High Court held that ITC cannot be denied to a genuine buyer just because the seller didn't pay tax. In the Ecomgil coffee trading case, the Supreme Court said that while buyers must prove the authenticity of the transaction, they shouldn't bear the brunt of another's non-compliance. The principle is simple yet powerful. Genuine trade should not suffer because of someone else's wrongdoing. Now, you may be wondering, this was under VAT, not GST, so how does it matter today? Well, under the CGST Act, as you know, Section 16(2)(c) puts a condition that ITC can be claimed only if the supplier has paid tax to the government. But this Supreme Court judgment questions that strict interpretation. It reinforces that ITC is statutory right, not a favor from the government. If you have done your part, verified your supplier, paid the invoice, and have proper documentation, you shouldn't be penalized for what happens later. And the judiciary seems to be on the same wavelength as well. The Madras High Court in D.Y. Bithal case criticized the department for punishing buyers without taking action against defaulting sellers. Similarly, the Calcutta High Court in Suncraft Energy and Loknath Construction quashed ITC demands where no supplier side verification was done. All these cases echo one strong message. The tax administration must ensure fairness and equity of justice and not harass genuine taxpayers. This Supreme Court verdict isn't just about one case, it's about restoring faith in tax fairness. The message is clear. The law must operate not only in letter but in spirit. The government cannot go on a fishing expedition to find defaults. Burden of proof must be shared fairly and not dumped entirely on the buyer. This is more than a win. It's a statement of justice, equity, and accountability in the GST era. So next time the department questions your ITC despite your compliance, remember the Supreme Court stands by the genuine taxpayer. If you found this update insightful, hit that like, subscribe, and share button because awareness is your best defense in tax law. Stay tuned. Thank you.